Now, our next panel is an ethics session that will address protecting data in class actions and fund administration. Everyone knows cybersecurity is a widespread threat that can impact any law firm or claims administrator. This topic will be moderated by my client and friend, Brent Landau, the global managing partner of Hausfeld. Brent is also an ethics professor at the University of Pennsylvania Law School. Brent?
Thank you very much, Chris, for that introduction, and I'm truly honored to be participating again in this conference. Let me introduce my fellow panelists. Christopher Dalton is a shareholder at Buchanan, Ingersoll, and co-chair of the firm's class action practice group. He's defended scores of consumer class actions in state and federal courts around the country. Chris was also a member and chair of the New Jersey Supreme Court Ethics Committee for the Newark area from 2004 to 2012. Allison Grande is a senior reporter for Law 360, which she joined in 2009. She has covered privacy and cybersecurity issues since 2011 and has written more than 4,500 articles, including stories about the cyber risks that companies and law firms face and how they're tackling them, as well as data privacy laws in the United States and Europe. We're going to start today with a polling question. No, I'm not seeing the right polling question come up. Thank you. Okay, if you can all see the poll now on the screen, the question is, what percentage of law firms have been hacked? So take a moment to give your answer. 26%, 66%, 80%, or 100%. Just a moment. No penalty for guessing wrong. All right, I'm going to share the results. So nobody said 100%, and then about half of you said 26%, and 66% with some of you saying 80%. I'm going to now share my screen. You should be able to see our polling question up there again. And the results are, you're all right. 2019 survey by the ABA found that 26% of respondents reported that their firms had experienced a data breach. A 2017 report by Logicforce found that 66% of law firms had reported a security breach of some type. Back in 2015, Mandiant found that 80 of the 100 largest law firms had been hacked since 2011. And I've got up on the screen a quote from a guy named Robert Mueller, back when he was director of the FBI, and he said that there are only two types of companies, those that have been hacked and those that will be, and even those are converging into a new category, those that have been hacked and will be hacked again. Some of you might have heard a variation of that line, that there are two types of companies, those that have been hacked and those that don't know that they have been hacked. So this is an important issue for all of us in the profession. So I'm going to talk today about some of the ethical rules that apply when there is a data breach and how those apply in the class action context. Then Allison will discuss some recent examples of class actions where this was an issue and some lessons that we can take from that. Finally, Chris will share some tips and best practices for minimizing risks in this area. At the end, we will have time for your questions, so please do put those in the Q&A as we go. A data breach gives rise to some important ethical obligations under the rules of professional responsibility. The ABA recently gave a detailed overview of these in Formal Opinion 483, which you can find on the website for this conference. I'll give an overview of some of the key legal rules that apply, focusing on the ABA model rules that have been the basis for the rules adopted by each state. But as always, you'll want to make sure that you look at the rules applicable in your relevant state in case there are any differences compared to the model rules. So there are three main duties of lawyers to consider, the three C's: competence, confidentiality, and communication. So we'll look at each of those. This is the duty of competence. As lawyers, we have an obligation to have the knowledge reasonably necessary for the representation of our clients. And as comment 8 to that rule makes clear, that required knowledge includes keeping up to date on changes in the law and its practice, including about technology and its risks. So if you're not staying informed about risks like data breaches, then you can't fulfill your duty of competence as a lawyer. Next is the duty of confidentiality. You probably know that the duty of confidentiality means that lawyers can't reveal client information without permission, but it also puts an obligation on lawyers to make reasonable efforts to prevent the inadvertent or unauthorized disclosure of client information. What is reasonable depends on the circumstances, and there's a comment to this rule, comment 18, that says that the factors to be considered include the sensitivity of the information, the likelihood of disclosure, and the cost involved. But lawyers who don't take any affirmative steps to protect their clients' information are not complying with this rule. Then we have the duty of communication. Lawyers have to keep their clients reasonably informed about the status of the matter. And as the ABA noted in Formal Opinion 483, this means that clients must be notified when there's been a data breach involving their information. And as the ABA says, that obligation exists whether or not the data is held by the firm itself or by a third-party online storage provider. So those are the three C's: competence, confidentiality, and candor. And they require lawyers to stay informed about technology and its risks, take affirmative steps to secure client data, and notify clients when there's been a breach. So how do these rules apply in the class action context? Well, as a general matter, class counsel have an attorney-client relationship only with the named plaintiffs, not with absent class members. That's one reason why conflicts of interest don't arise when class counsel might be adverse to absent class members in unrelated cases. But some duties of lawyers under the rules of professional conduct do exist towards absent class members as well, even though they're not formally clients. For example, some years ago, the New York City Bar Association issued an opinion that the duties of competence and confidentiality, that's two of the three C's, do apply when absent class members are involved. So that means that class counsel have the same duty to stay informed about technology and its risks, and the same duty to take affirmative steps to secure class member data, as do lawyers representing individual clients. And in addition, lawyers have fiduciary duties both to the court and to absent class members as class counsel under Rule 23. Finally, the duties of class counsel can extend to outside service providers engaged on behalf of the class, which can mean that those lawyers have duties when it comes to settlement administrators as well when they hold class member information. Model Rule 5.3 governs the use by lawyers of non-lawyer assistants, and it, as reflected here in comment 3, when lawyers use non-lawyers outside their firms, such as using vendors who maintain databases in complex litigation or use internet-based services to store client information, the lawyer has an obligation to make reasonable efforts to ensure that those services are being provided in a manner that's compatible with the lawyer's own professional obligation. That again means the 3 C's. So that means that class counsel, and maybe defense counsel too, depending on the nature of the settlement, can't simply outsource their obligation to protect class member data and appropriately handle data breaches, but instead, we must ourselves make reasonable efforts to ensure that the settlement administrator will do so. At a minimum, that means asking the right questions at the outset and staying informed about what develops in the case. So that is an overview of the rules of professional responsibility that apply to all lawyers, including class counsel, when it comes to data breaches and protecting client information. If anyone has questions, we will definitely take them at the end, so please put them into the Q&A as we go. And I'm now going to turn it over to Allison.
Great, thank you so much. Thanks for the introduction, Brent, and hello, everyone. I am Allison from Grande from Law 360, and I'll be talking a little bit today about different liability risks and, you know, for not following the professional rules of conduct, or just what happens if there's cyber attacks in general that impact, especially, you know, professional services firms. So like Brent, I'll also start with the polling question. Let's see if I can, let's see, is relaunch polling? Is that what I do? I think so. Sorry. So that's not my polling question. Well, let's see if we get the polling question up. Okay. Maybe I have to look down here. Oh, here we go. Polling question number 2. Here we go. Got it. Just is kind of like, you know, Brent's was more of kind of a, you know, trivia question, you know, and mine's is a little bit more of a kind of take the temperature of the room question. Just kind of get an idea of how high a priority do you feel like cybersecurity is where you work. Obviously, cybersecurity protections that are in place and protocols are different based on probably the industry you're in or the size of your company. But it's something that obviously everyone should probably be thinking about. So, you know, do you think it's taken seriously? You know, do you get emails all the time? Do you always going into trainings about, you know, especially when it comes to things like phishing and not clicking on links and things like that? Or do you you don't even know if your company has a cybersecurity plan? Or, you know, if you had an incident and someone called, you'd be like, I have no idea who to even direct you to. You know, would you even know who to direct someone to if they had any questions about security? So I guess, let's see, it's been about a minute. So let's see. I guess I could end polling and then share the results. So it looks like, if everyone can see, it looks like about 49% said that they receive constant cybersecurity related reminders. Then next, it's a definitely consideration, but not high priority. And at least almost 20% said they've probably seen at least, you know, they've seen at least one cybersecurity related incident. And actually no one says that it's a very low or non-existent on the company's radar, which is very interesting and probably very reflective of the society and the situation we're in right now, where cybersecurity is definitely a consideration for all companies. So I'm going to share my screen. Okay, so hopefully everyone can see that now. Let me see if I can. There we go. Slideshow. I'll launch my slideshow mode and very good. Okay, so yeah, as I just mentioned, cyber attacks impact, you know, can target or affect anyone. It doesn't matter the size of your business and or what industry you're in or what data you hold. And hackers are getting more sophisticated and more persistent. It's constantly described to me as an arms race. New cybersecurity tactics are found all the time. Companies, discover one vulnerability or one method for patching their system, and hackers usually are one step ahead already. They've already found a new vulnerability. They've moved on. They've learned that their tricks don't work. So they move on, and it's just constantly trying to one-up each other. So if anyone here is in charge of cybersecurity or data security at their company, they definitely have a good idea of how that's working. And, and also there's been a lot more partnership recently with IT departments. It's not just an IT issue anymore. It's becoming more of a board issue. It's becoming more of everyone in the company needing to be involved. It's coming into the C-suite, and attorneys are advising, corporate counsel and outside attorneys are giving briefings during corporate board meetings. It's something that companies really need to think about, and even HR needs to be involved. Obviously if there's an incident, they need to know how to respond, and what their posture is and what their role is in breach response. And probably no surprise, the pandemic is making this worse. But a lot of reports, that was one of the first features that we wrote when everything started happening in March, when everything started to shut down, was that attorneys were saying they were busier than ever. Cybersecurity attorneys were saying they were busier than ever. They were seeing more data breaches than they ever have. It's just a lot of, especially ransomware attacks, which is, typically when you get, you click on a malicious link and it puts ransomware on your computer and it locks you out of your system. It encrypts your files, you can't get it, and you have to pay the hackers a ransom, some money to get your information back, to get it unlocked. And even I've been talking to some security experts that say they're even getting more sophisticated. Now a lot of times they're not just locking companies out of their systems, they're actually taking the information as well. And then you have to pay so that they won't post it on the dark web or leak it somewhere. So that's getting more and more complicated. And, and there's been just a lot of fraud as well, which ties into, class action settlement administration, because more class action settlements are going online. I mean, you see websites pop up all the time for, settlements across everything, privacy settlements, but antitrust, everything. There's claims websites you go to. So where they ask you to put in personal information so you can get a claim. So how do you know if that website is legitimate? I mean, a hacker can just set up a website that looks pretty legitimate, and then you're putting all your personal information, and now your hackers have your name, your address, social security number, very important credit card information, maybe, important things about you. So that's getting, with the pandemic, everyone's kind of removing to remote work. I mean, overnight, IT departments had to shift everything overnight. And, you had to, get everyone laptops and get everyone on the VPN and make sure their home networks were secure. And, that's something, if you're going to make a switch like that in corporation, it usually is it's a drawn out process, but this had to happen, in a week. And people are distracted. Most people, if you're like me, giving this presentation from the kitchen table, most people are working from their kitchen tables or their home offices. So, people are distracted, and, you see a link, you're like, okay, I'm going to click on that. Like, you don't give it a second thought. And IT departments are stretched thin, just making sure, computers can connect, let alone monitoring networks to see if any hackers are trying to get in. So it's just been a lot for companies now. And so, and what hackers are looking for, I mean, you can have the best data security and still get hacked. I mean, hackers persist. If they want to get into your system, they'll probably find a way, is what cybersecurity experts I've talked to have said. They'll just keep looking for a hole, looking for the weakest link. And that's really what they're looking for, is the weakest link as well. So if you have the weakest security, they're going to get in. And if you haven't trained your employees, they'll probably get in. And like with the big Target breach in 2013, I believe that was through an HVAC vendor. It was through one of their vendors, and that's how they got access. So, you have to worry about your vendors as well. There's this slide that is up right now. The law firms and settlement administrators, that kind of fits in. They have very enticing data. They hold a lot of confidential data, as Brent was just talking about. They have the ethical duty to protect it, but that's because that sounds pretty juicy for hackers to want to get access to that information. So law firms are, pretty targeted, even settlement administrators. This is a survey from Net Diligence back in 2018, I believe. And you usually think of, the most sensitive industries, healthcare, financial services, like those are the ones, but this seems to show that professional services, like law firms and accounting firms, they at least this year, in this particular year, submitted the most cyber claims. The quote here from Net Diligence presidents about the big three becoming the big four. Hackers are starting to, maybe they've already caught on, but, we're starting to see more of this. So it's, we're starting to see, cyber crime attacks or, crimes of opportunities. And, many professional services firms are sitting ducks sometimes. And because, that you think of healthcare and financial services, they have laws covering them like HIPAA and Graham-Leach-Bliley, but, it might not be as top of mind on professional services companies' radars. So that could lead to some problems sometimes. So I'm going to talk about two examples that, Chris is going to talk to you in a little while about what steps companies can take, to protect themselves and, from these kind of risks. But I'm going to talk about some fallout and liability, like some real world examples of what's happened. So one is the Aetna case that dates back to 2017. So as you can see here, Aetna what happened was Aetna sent, as part of a settlement, class action settlement, the settlement administrator sent out this information. So Aetna had been accused of violating HIV members' privacy by requiring them to fill prescriptions online instead of in person. So they settled that case, and as part of that, they had to send out a mailing to their HIV positive patients to let them know about how they can fulfill their prescription. So as you can see from the picture, what happened was the envelope they sent was this window envelope, which was a little large, and it looks like it kind of slid a little bit, the information. So anyone viewing this envelope could see, HIV medication, and, they can see clearly the name and address of the person. So that was a little bit of a problem. Aetna did this to settle a class action. And then what happened after this happened, and a consumer watchdog group kind of brought it up. So what happened was they were sued again. So they were facing another class action after just resolving this class action. And the class action, they ended up paying $17 million to settle a consolidated consumer class action. And then also Attorney Generals sued as well. The New York Attorney General was $1.15 million. There was a California Attorney General. There was like a multi-state investigation. I believe it was New Jersey and Washington. So they had to pay a lot of money. And that's typical. That's what we see a lot of times. Almost all the time when there's a big breach. Usually, I hear about a breach, something like Target, Home Depot, Sonic, JP Morgan, Capital One, the first, you see the breach notification, and then usually I'm going and checking the docket to see if there's a class action, because a lot of times class action plaintiffs have complaints drafted and ready to go. I believe someone told me once they'd forgotten to change the name from the last case they filed. It was the wrong plaintiff in there. There was a reference to the last class action they had filed against someone who had a data breach. And regulators are getting more active too in places like state AGs. Consumer protection and privacy are a big issue for them. So they're filing a lot of, they're going after companies a lot, launching a lot of multi-state investigations. That's big in this area for privacy. So lots of multi-state investigations and coordination. And so there's a lot of liability risks, and it affects all companies, especially the big name ones that, they kind of want to make an example of, so other companies will know, yes, security needs to be taken seriously. So Aetna turned around and they sued the plaintiffs in the original class action, the plaintiffs' firms, which was this law firm, Watley Callis, and also Consumer Watchdog was, I believe it was the plaintiffs' firm, and they were involved in the case. They sued them, and then as well as their settlement administrator for indemnification, because they were obviously part of the class action process as well. And what happened in that case is the settlement administrator they failed to get the case dismissed, and they settled for an undisclosed, I believe the settlement was undisclosed. And the law firm and the Consumer Watchdog continued to fight. And the California, and they got their claims dismissed, but then the California, I believe it was the Second Appellate District, Second Appellate District, they revived the suit in a 2-1 ruling in July. And because what the law firm and Consumer Watchdog had argued is that it had to be tossed out because it was subject to California's anti-SLAPP law, which protects First Amendment speakers from being sued. But what the appellate court decided in their split decision was that Aetna's claims didn't arise from protected speech or petitioning activity. It was based on professional negligence, so it wasn't subject to this anti-SLAPP statute, which is, I guess, Code of Civil Procedure 425.16. So that got revived, and actually, I believe the whole appellate panel back in August affirmed that. So they're still having to fight that. So this example shows the kind of the risks of, snail mail and, old school kind of, settlement administration, and HIPAA, which is, you think of health privacy, HIPAA privacy law. This next one has to do with Epic, which is a legal services provider. They do a lot of different legal services, including class action administration. And so this was in February, they were hit by simultaneous ransomware and malware and ransomware attacks. They, obviously can happen to anyone, and they ended up getting sued. A lawsuit got filed in July, a class action. So they got sued under California's new Consumer Privacy Act, which took effect, it got passed in June 2018. It took effect January 1st of this year. It doesn't have a broad private right of action. Like, the law is, what it does is what the law does is that it gives you, the consumers, like, broad, like, access, like, right to access their personal information and to delete it and to, correct any accurate information. So consumers can't sue for those kind of, like, transparency and access and choice rights, but consumers can bring a limited right of action. They can sue if a business fails to maintain reasonable safeguards of information that result in a breach, theft disclosure. And actually, plaintiffs since January, I believe there's been over maybe 70 or so suits that already filed citing the CCPA. Plaintiffs' bar seems to be kind of stretching it a little bit, and they sued Zoom under the CCPA for just sharing third-party data with like Facebook and Instagram, and allegations over that, sharing personal data without consent, saying that was a breach. We still have to see how that plays out, obviously, because it's just very early stages of that. So Epic was sued, and this is obviously playing out. And the plaintiff was Epic had his information because he had submitted a tax form with his social security number, and in relation to a class action settlement that Epic was administrating, that he was a class member of. So the CCPA, I mean, it's just kind of another form of liability. I mean, you think of the traditional things. I mean, there's another you can face, and Epic, I believe, is fighting it and obviously disputes the claims. The plaintiff is claiming that they didn't have strong data security. They were running outdated Windows, but that's just, obviously, it just got filed in July, so it's still pretty early stages. So yeah, that's just, and that you can get the statutory damages. That's a game changer. Obviously, that's $100 per $750 per incident. So that could add up pretty quickly, and easier than having to prove actual damages as well. So yeah, that's kind of the risks. And I mean, I'll turn it over to Chris now, and to see, he can talk to you all about some best practices and how to kind of avoid having these kind of liability risks pop up for you.
Great, thank you, Allison, and thank you, Brent. As Brent mentioned, I'm an attorney with Buchanan, Ingersoll, and Rooney. I'm sitting in my Newark office today, Newark, New Jersey, not to be confused with Newark, Delaware. I've been asked to talk a little bit about trying to mitigate the risk that you have when you're handling either class member or client data. And I'm going to share my screen if I can do so. I've done a little slideshow so you don't have to look at my face here. Let's see. All right. Are you folks able to see my slideshow, Allison, Brent? Okay. So listen, I'm not an expert or a computer nerd or anything like that. I am just trying to do, as Brent said, keep myself abreast of things that are going on and developments in the field, so that I can abide by my ethical obligations to be aware of technology and changes in the technology. In going through this, I've been able to try and summarize data protection in one word, which is ARG. It is a landmine. As Allison explained, you can try and do the best sorts of things to protect your data, and still some of these pernicious actors can get into your systems and either infect it with malware, or it can take your systems hostage. So all we can really do is try and do the best we can. And again, the rules of ethics set a guideline, and essentially, the issues become sort of issues of negligence, as Allison and Brent both said. So in doing this, I've done some research. I found the National Institute of Standards and Technology, which is part of the Department of Commerce. I always thought that they just basically decided how many inches go in a mile and how many ounces go in a cup or a gallon, but they also have this whole Computer Security Resource Center, which has a ton of information on it. I, as a layperson, wandered through it, but if you have some IT professionals, they could probably guide you through it in great depth. There's just a ton of resources there in terms of just as a general industry-wide, not specific to the law, not specific to class action administrators, just things that folks in industry can take into consideration in trying to protect sensitive data. And they've kind of come up with 5 bullet points for protecting data that they've summarized as identify, protect, detect, respond, and recover. And I'm going to really focus on the first 2, identify and protect. The latter 3, detecting, responding, and recovering, those really speak more to the systems and the technologies that you're using. And depending upon the size of your firm or your enterprise or your business, this may be something that you do in-house, or this may be something that you outsource to a vendor, but they are things that I'll touch on, but things that really are more technological than necessarily what we in the day-to-day practice and guided by our ethical considerations are going to see. So identify, you want to look at your business enterprise. You want to look at what you're doing. We're law firms, and so, we are either litigating a case, or perhaps, we're on the transactional side and we're doing a deal. What kind of data are we holding on to? Oftentimes, and particularly in the class action sphere, we've got PII, we've got people's names, addresses, phone numbers, email addresses, in some instances, financial records as well. I think, as Allison said, the genesis of one of these consumer class actions was that the hackers got in, the administrator was holding a W-9 that had the class member's social security number on it and name and address. We're holding on to these things, health records, that Aetna case, double damage, because you had the exposure by Aetna of the health information, and then the exposure in terms of trying to settle the class action, again, re-exposing the health records and information. So you want to take a look at and identify and understand the types of information that you're holding onto on behalf either of your client or that you or your vendor, the administrator in a class settlement, is handling. And you want to make sure that you understand what it is and understand the risks of holding on to those things. Um, you want to look at what kind of laws and regulations are governing the data or the information that you're holding on to. HIPAA, we talked about, Gramm-Leach-Bliley. The bugaboo of anybody that does any business with European entities is the GDPR, the General Data Privacy Regulation, which well, that could be the subject of an entirely separate presentation, but it is a landmine to watch out for. And then you have the state laws. You have the California Consumer Privacy Act. You have not so much we're dealing with Illinois biometric privacy, and then you have not just statutory law. You have the common law issues of straightforward old school negligence. What did you do to protect the data? What steps did you take? So there's a whole host of legal and regulatory controls over how we handle the data that we're given either by class members or by our clients. You want to look at where are you keeping this data. I mean, back in the day, we just used to have a laptop on our a desktop on our desk. I am a bit of a dinosaur. I do remember those days. With one of those floppy disks, and we would hand off the floppy disk from, myself, my colleague, to my secretary, and that was how we did it back in the day. Well, now we've got, I've got a server room behind me here with a bunch of stuff that's hooked up to our main office in Pittsburgh that goes through, all sorts of data centers that lands up through Wi-Fi on my laptop. I can hook into our document management system through my iPhone. I can take stuff home on a thumb drive. I can throw it on an external drive. We use the cloud, whatever the heck that is, because I'm still clueless on the cloud, but my 17-year-old kid can probably explain it to me. But we have all of these places that this data is resident, and every one of those places is a potential hack. So you want to know where you're storing your data, and particularly, we'll get to it in a moment, how you're storing it and how you're maintaining protection. You want to think about who wants your data. Is it hackers? Is it identity thieves who are going to try and spoof your clients, your customers? Is it the radical left, because they seem to want everything these days? Sorry, but who wants it? Who wants your data, and why do they want it? What do they want to do with it? And how can it harm the folks? So this is all to the point of being cognizant of what we have and how it can be exploited. To the detriment of either our clients or class members, just any third party. So once you've identified everything, you want to talk about how do you protect it. And there's some basic things. You encrypt your data. Password protection is another thing that we use, but encryption tools and technologies. We're accustomed to all of those HTTPS websites where when we're going and buying something off Amazon, it's encrypted, it's protected, and those sorts of things. You want to also think about in addition to where you're storing it, how you're storing the information, who can have access to that information. Here we are. I'm sitting in my office, and in the before times, people could come and visit the office, and we would have clients would come in. We might have vendors come in. We might have witnesses and such. And we have a Wi-Fi access here in our office, and you type in the password and all of that. Well, they're in your Wi-Fi system. It's a public Wi-Fi system, but these hackers and such can be pretty nefarious. So, how secure is that system? Are you, segregating? Are you segregating the data? Is the data on a widely accessible database or server or storage device of some sort, or is it segregated on something that you can only get access to? I mean, I think back to again, I'm a dinosaur, but we used to put really sensitive stuff in paper form in a filing cabinet, and we would have like these orange or red signs on it that said super secret, highly confidential, this group of people only, and there would be a key and all of that. Well, you need to do the same sort of thing with these electrons. You need to make sure you've locked them down, and you also need to make sure that when you're transmitting the stuff, you can't just, it's an easy thing for all of us to do, to just, slap that Excel spreadsheet, attach it to your email and send it. Couple of dangers there. One, maybe you misaddressed it, and you sent it to the wrong person. Hell, we've all done that. We've, started to type in Allison Grande and we get Allison somebody else. And the next thing you know, we've shared something that we shouldn't share. We're red in the face at the very least. So you want to try and tell, the better method these days is encrypted, password protected FTP transfers. It's much more secure that way. You make sure as well that you're getting the link to the right person, and then separately you get the password to the right person, and it's two steps in that regard. And then we're going to have these pernicious actors. We want to make sure that we have backups and we have systems that we're keeping track of we're backing up the data, and we have a recovery process, a recovery system. You want to protect the systems. Again, you're talking about limiting access. Who can get access to the systems? Password protection, multi-factor authentication. I was one of the panels on. I think today is Wednesday, so it was Monday. One of the panels on Monday was talking about multi-factor authentication. It's a great way of making sure the right people are getting the right things. If you're in a larger enterprise, even smaller enterprises these days too, we have VPNs. We can log in from home. That's kind of how we've all been working for the last 6 months. At least the three of us on this panel who are located in New Jersey and Pennsylvania have been working from our kitchen counters and our basements for the last 6 months. How secure is your VPN? Again, as Allison said, these folks are deploying, highly sophisticated weapons, and let's call them weapons because they're trying to gain access to your systems. Secure web browsing and email. Our firm has a very, I think, fairly sophisticated IT protection system. There are times when I try and go to a website, a legitimate website, please, a legitimate website, not a gambling site, and I'm told that I'm being denied access because some keyword was picked up in there. And I've even had instances where I've been asked whether I'm properly accessing one of my settlement websites because of some of the information some of the keywords that show up in that. So, these are good firewall type of protections to put in place to make sure that you or your people aren't going there. Email, I mentioned, we oftentimes have that autofill function that ends up putting in the wrong name and the wrong address. We've all seen far too many times when somebody hits a reply all instead of reply to the sender. In fact, our firm went so far as, and I know other firms have done it, they've moved the reply all the way over here so that it's not anywhere near the reply button, and we still have people hit reply all. You want to make sure that you're auditing, monitoring, keeping logs on your systems, particularly where vulnerabilities might exist, and monitor attempts to gain access, actual breaches, how things have been broken. If they've been broken, keep an eye on things, and that all falls down to really a team of very sophisticated and well-trained IT professionals, because the folks who want to get in are pretty sophisticated these days. It's no longer the old Nigerian prince scheme. It's a lot more sophisticated, and as they progress, we progress, and unfortunately, the bad guys tend to be ahead of us on that a little bit. It's critical too to protect your people. To train your people, you need to have policies. You want to have policies or procedures, guidelines, something telling folks like, this is what you should do. You see something suspicious, see something, say something, kind of like you see when you're walking through the airport again, back in the before times when we went to airports. If you see something, say something. Train folks on your policies and your systems, what you have and what they do. You want to give folks examples. I mean, it's one thing to say, watch out for spear phishing without giving an example. You need to give examples of it. And then another important step is to test the folks. Our firm and a lot of firms that I know of will send out random phishing, random malware without the bad stuff attached, and see how people react to it. And then we get an email the next day saying, hey, you got this email, and by the way, 33% of you clicked through and shouldn't have done that. And had it been a real attack, we'd be up a creek without a paddle. So training and testing is important. And something also not to forget about is departing employees. And there are some stories that we've seen in the trade press where either departing, because we're lawyers, we monitor like Law 360, and Allison might have written a few of these stories about a departing employee. I think there was one instance where an associate took some files with him or her and then tried to hold the former firm hostage to get those files back. So you want to make sure that when people are leaving, you're checking to collect up all of their toys, check their laptops, check their phones if it's a bring your own device kind of place. Make sure that things aren't walking out the door with your departing employees. All of us are susceptible to that kind of information or data breaching. And you may want to review with them as well the penalties that can arise if they don't necessarily abide by your policies and your procedures. So those are the main things in terms of identifying and protecting. Just touching briefly on the detect, the respond, and the recover. Detection, one of the things that I read, they referred to it as conmon. Constantly monitoring. You want to constantly monitor your systems, watch out for active threats. I think in one of the cases I read about, there were like 24 attempts to access the company's system, before they actually got in, and before the hackers actually got in, and each attempt was more sophisticated than the prior one. And only by monitoring what's the attempted penetrations will you be able to hopefully adapt your systems and your software providers. We keep getting those updates and patches from Apple and from Microsoft. A lot of those are also aimed at patching things that could be the weak spots in your software or your hardware that can be attacked by these attempted intrusions. Respond. Like Brent said, to borrow from Robert Mueller, there are two kinds of companies: those that have been hacked and those that will be hacked. So let's anticipate that we're going to have a hacking incident or an intrusion of some sort. Have a plan in place to respond to the various things that might happen, the scenarios that might occur. Have trained professionals that are ready to implement that response plan. Knowing who is responsible for doing what, rather than ending up in a fire drill situation. And then after the dust is settled, look at what happened and try and learn from what happened and to improve your systems. And then if there is a situation where you're seriously, your systems have been seriously affected, you'll have a recovery plan, implement that recovery plan. I think in that Epic intrusion, they did end up taking their systems offline very quickly, and then spending some time to reboot the systems using disaster recovery plans. We often back when we started talking about disaster recovery plans, we were thinking about a fire in the building or something that power failure that shut down our servers. Well, it's not just power failures or building fires, it's bad actors that's just kind of what they want to do, whether they want to do it for money or for a laugh. So those are kind of things that we've come across, that I've come across in reviewing a variety of things. And so I have a polling question, and I think I'm going to see if I can throw up this email. Let's see if I can move this into my share screen. Let's see. Well, if we go to the next slide, I believe it's in there. So if you can see this, hopefully, we'll throw up, how do I, is there a button for sharing the questions? Oh, here we go. So you received this email on the right here this morning. It comes from Debbie Estridge. And this is actually one that I got Friday, I believe. Yeah, Friday, September 18th. As I'm preparing this program, I get this email, and it's got a case number 3:20-CV177. I'm thinking to myself, I know I have a case. Yeah, I mean, these are my case numbers that I'm going to see in federal court, and that's where I find myself most of the time. And Debbie's sending me something from this folder or from this case. I get this, I send it over to my IT folks, and I'm going to end the polling because I'm going to give you the answer, send it over to my IT folks, and guess what? Lo and behold, of course, it's a spear phishing expedition. So what do? Do you click on the link? Maybe you're tempted to do that. Do you call IT? Do you delete it? Or do you forward it to someone that you don't like? So the answer actually is D, you forward it to somebody that you don't like, but let's see. Most folks said call IT about it. Have I shared the results? Nobody said forward it to somebody you don't like, which I'm kind of sad about. But yeah, the two best answers are get your IT folks to take a look at it, because if it's coming from a domain and it's being sent to a lot of other folks in the firm, your system can block it. If other people are getting it, they can alert the folks around the firm, watch out for this thing. And then if you don't have that technology or capabilities, just delete it. Get rid of it, and avoid having your systems hacked, and either being subject to a malware attack or a ransomware attack. I give you guys credit, y'all learned. So obviously you're paying attention to everybody here on our panel. I definitely appreciate everyone's time today. It's a brave new world out there, folks, and every day it's changing. So you got to stay on top of these subjects, not simply for your ethical obligations, but just because there's lots and lots of liability out there if we don't. So I'll turn it back over to our moderator, Brent, and try and find my stop sharing button, and appreciate it.
Well, Chris and Allison, thank you both so much for sharing some of that practical information and tips, and also talking about some of what's going on out there in the world. This really does affect all of us, whether we know it or not. We all have this shared responsibility to make sure that we're doing our part to keep data safe. Hopefully you can tell by now that just the fact that somebody is hacked doesn't mean that they didn't take the right precautions or did everything they can do. This literally can and does happen to everyone, and I think it says a lot more about lawyers and the people that we work with when it comes to how we handle those situations, how we best fulfill our duties. We can ask the right questions at the front end, but no matter what we do, some things are going to happen that breach our defenses, and we're going to have to make sure that we deal with it in an appropriate way. Let's see if we have any questions that have come through. I don't see any in the Q&A or the chat, at least not yet. Please do type it in there if you have any questions for any of our panelists. We have a few minutes still that we can talk about.
Well, thank you so much, Brent and Chris, for sharing this panel. And let's do leave the line open for some questions. Our next panel is slated to start at 1 o'clock. So for those of you who have been listening all morning, if you don't have a question for Chris or Brent or Allison, why don't you take a moment, perhaps refill your water, and then we'll reconvene in a few moments for our last session of the conference. Thank you so much.
Thank you, Jeff, and it was really a pleasure to be here speaking with all of you. Give just another moment.
Allison, thank you very much.
Thank you. Thanks to everyone.
Bye.
Bye.